Good afternoon. We're here in DOR on behalf of Justin Serlich and Heather Bindle. This is 2023 31828 FMCI. These proceedings are being digitally recorded by the Office of Digital Court Reporting. No other recording is permitted. We're noticed for hearing today on a motion to contest driver's license and motor vehicle registration suspension, only if the issue of the driver's license and motor vehicle registration as to whether or not a child support delinquency does or does not currently exist for the currently entered orders, and if so, Department of Revenue's position on the driver's license and motor vehicle registration. Document number 188 in the court file for everyone's reference. No other issues are noticed for today's hearing, and 15 minutes have been set aside for today's hearing. All right, so...
I'm sorry, I'm hearing impaired. How much time is set aside?
15 minutes, ma'am.
Thank you.
I do have a copy of the arrearage affidavit. I'll try to speak louder if that'll help.
I appreciate you. Thank
Sure.
you.
I do have a copy of the arrearage affidavit and clerk's payment history. I'll take judicial notice of that as well as of the rest of the court file. The arrearage affidavit says that there's $35,783.50 owed on the case. It says that of that amount, $4,710 of it is listed as what is called a ongoing child support delinquency on the $785 currently ordered ongoing child support payment for the children listed on this case. I do have a copy of the payment history, which shows the writ payment of $1,000 was made on 3/24 of 2025, as well as a sheriff's $90 fee, as well as a $5.25 clerk fee. It does not list any other payments that have been made on this case, and I understand that you might disagree with the order that has entered, but it is the order that is the order unless or until it is changed or overturned.
Correct.
So based upon the orders which have entered, do you have any evidence to present of payments that you have made on this case through the system as ordered for which you have not received credit, ma'am?
No, sir.
Okay, thank you, ma'am. All right, just for all of our information, because the court would like to know, and Ms. Spindle might like to know as well, I'm going to ask the Department of Revenue, what is the current status on Ms. Spindle's driver's license as we all sit here right now?
On hold pending the outcome of today's hearing.
So the license is still valid and it can be saved if an arrangement can be made, is that correct?
Correct, Your Honor.
All right. Ms. Spindle, is there anything else you want to say before I ask the department what they would like in order to not suspend your license?
Okay. Well, as you can see, I have a lot of documents in front of me, and I would like to take my full 15 minutes to present all of these documents to yourself and the Department of Revenue.
To the extent the documents are relevant to the issue, to the very narrow issue of whether or not a delinquency currently exists based upon the current orders which currently exist, that's fine. If they are directly relevant to that issue.
All of it is
However,
directly relevant, sir.
Okay. What would you like to present?
I would. Okay. I'm currently in my...
The bailiff will get your documents for you.
Okay, thank you. So, first and foremost, the April 27, 2022 Illinois order is void ab initio.
And Judge, I'm going to object.
All right, guys, what starts as a brief 15-minute hearing quickly proves to be anything but routine. The courtroom gathers to decide one specific issue: whether Heather Bindle's driver's license should remain valid despite an alleged child support delinquency. Before testimony even begins, the hearing officer narrows the scope of the case, explaining that today's proceedings are not about custody, parenting disputes, or past court rulings. Instead, every argument must focus on one critical question: does a legally enforceable child support delinquency currently exist under the orders that remain active today? The court immediately reviews the official payment records, and the numbers paint a troubling picture. According to the Department of Revenue's affidavit, more than $35,000 is allegedly owed, with several thousand classified as overdue ongoing child support. The payment history reflects only a limited number of recorded transactions, leaving the hearing officer with little evidence that additional payments were made through the proper system. When Heather Bendel is asked whether she possesses proof of uncredited payments, she honestly acknowledges that she does not, shifting the hearing toward a completely different legal argument. Instead of disputing individual payment records, the hearing turns toward the status of Bendel's driver's license itself. The Department of Revenue confirms that the license has not yet been suspended and remains temporarily valid while the court considers today's motion. Realizing that the situation is still salvageable, the hearing officer gives Bendel one final opportunity to explain why the suspension should not move forward. Rather than offering a simple response, she prepares to present a stack of legal documents that she believes completely changes the foundation of the state's entire enforcement action. That's when the atmosphere inside the courtroom changes dramatically. Heather Bendel argues that the underlying Illinois child support order is legally void from the very beginning because, in her view, the issuing court no longer had jurisdiction when the order was entered. She tells the hearing officer that she recently filed multiple legal motions challenging enforcement and insists the alleged debt should not even exist. Before she can fully develop that argument, the Department of Revenue objects, setting the stage for a tense legal confrontation over what issues this hearing is actually allowed to address.
And
Judge, I'm going to object at this time.
Yeah, those matters
It's
are
not
already on
relevant for
appeal, I
today's
believe,
purposes.
correct?
Yes, and I would appreciate it if I could actually speak.
Okay, I'll listen
So-
to what you have to say if you wish to make a record, but those matters are already on appeal, and I'll not be passing on those matters today.
Yes. So, as I said, that order is void ab initio, as Illinois no longer had jurisdiction under the UCC JEA Florida Statute 61.501, rules as of February 13th, 2022, and is therefore void and cannot be enforced by Florida or Florida Department of Revenue. This morning before I arrived, I e-filed 3 different documents. One is objection to enforcement of unregistered foreign support order. The other is the memorandum of law in opposition of enforcement of an unregistered and improperly registered foreign support order to support the objection. And third is the motion to stay enforcement of driver's license suspension. The $33,000 or whatever is non-existent. It's void ab initio. And it is currently in District 5 Appellant Court. And this week I will also be filing in Florida Supreme Court to argue this entire case. This entire case has been all illegal activity between Justin Serlich, Mary Serlich, and Ira Serlich, Judge Stasia Warren, Serena Baldacchino of Rice Law Firm, and Judge Sandra C. Upchurch. Are all of you familiar with 42 U.S.C. 1983, 1985, and 1996?
And I'm not here to
I
answer your
hope so, because I will be filing that next against all parties that are violating my constitutional rights. I have had absolutely no contact with my children. My ex-husband is hiding my children behind this void ab initio
Judge, I'm gonna
order.
object for the record.
While you are not going to object to me, you are
As to where
violating my
this
constitutional
objection
rights.
made, I'll rule upon the objection. What is your objection, Mr. Holt?
Relevance, Judge, as to where the
All of
children
it's
are,
relevant.
have no bearing on today's hearing. Today's
As-
hearing
If you take away
is
my
an
driver's
objection.
license on a void ab initio order, you are
Ma'am.
violating my constitutional rights, and you will be subjected to 42 U.S.C. 1983, 85, and 86.
This is not a hearing on whether or not the court is going to take away your driver's
Okay.
license. This is
So,
a hearing-
Exhibit A-
Hey, let me finish my sentence, ma'am. This is a hearing.
You're violating my constitutional
This is
rights.
a hearing on your motion requesting that the court interfere with the Department of Revenue's existing statutory authority to suspend the license, which indicates that where any child support delinquency exists, the department may suspend the license. Now, we've already established that there are orders that exist that I understand you disagree with. We've already established that
All
those
void.
orders are on appeal.
All of it is void.
Okay, we've already established those orders are on appeal. I believe the circuit judge disagreed with your assessment of that situation.
Yeah, because she's part of the illegal activity, and she will be subjected to a 42 U.S.C. 1983, 85, and 86.
And those matters, as is your right, are on appeal in the appeals court, okay? And the appeals court will rule upon those matters in due course.
And it will go to Florida Supreme Court, and I will see everyone in federal court.
And that's fine. But unless or until those orders are overturned, those orders still
Okay.
exist.
Objection
And
to
understand that
enforcement.
I'm not a
Number
hearing
2, the
officer.
purported
I'm not
foreign
a
order
circuit judge,
dated
I'm a hearing
April
officer.
27th from Illinois has not been properly registered in Florida under Section 88. You cannot enforce something that has not been properly
Stand
registered.
by for a minute.
Please take all of these exhibits. They are in my file. Please hand all of these to the Department of Revenue. These are all exhibits. There you go. Violate my rights. I'm going to show you you're violating my rights. You cannot take away my driver's license on void order.
Sure, I'll look at it.
I have an LLC that I am starting from ground up. I just created Orbital Reach Marketing LLC. I am a full-time student at UW Parkside in Kenosha, Wisconsin, online for my MBA in marketing. I'm also in my certified paralegal program online at that same alma mater. I'm a full-time student. I'm a business owner that is creating my own business. I am also a public school teacher. I have filed multiple financial affidavits since November, and they have all been ignored. That financial affidavit shows that
All
I
right,
do not
guys,
have...
this is where the hearing suddenly shifts from a legal dispute to an emotional confrontation. Although the hearing officer allows Heather Bendel to continue speaking, he immediately reminds her that the validity of the Illinois order is already being challenged in a higher court and is not an issue he has the authority to decide today. Bendel refuses to back away. She argues that the support order was never legally enforceable and insists every dollar of the alleged debt is based on an invalid judgment that should never have been recognized by Florida authorities in the first place. 513 to 618. The tension rises even further as Bendel accuses multiple judges, attorneys, and government officials of violating her constitutional rights. She tells the courtroom that she plans to pursue federal civil rights lawsuits against everyone involved, citing several federal statutes she believes support her claims. At the same time, she describes a heartbreaking personal situation, alleging she has been separated from her children while continuing to face enforcement of an order she considers unlawful. The courtroom becomes increasingly difficult to control as legal arguments blend with deeply emotional accusations and growing frustration. Despite the emotional outburst, the hearing officer remains composed and carefully redirects the discussion back to the narrow purpose of the proceeding. He explains that today's hearing is not deciding whether the child support order is valid, nor is it reviewing the pending appeal. Instead, his responsibility is limited to determining whether an active court order currently exists and whether an unpaid child support balance remains under that order. Bendel repeatedly insists the judgment is void, while the hearing officer continues emphasizing that only an appellate court has the authority to overturn those existing rulings. Determined to strengthen her position, Bendel submits additional exhibits while explaining how a license suspension would severely damage her future. She tells the court she recently launched her own marketing business, is pursuing graduate studies and paralegal certification, and has filed updated financial affidavits showing she cannot afford the disputed obligation. From her perspective, suspending her license would only make matters worse by limiting her ability to work, build a career, and eventually improve her financial circumstances. The hearing has now evolved into a battle between strict legal procedure and personal
affidavit
hardship.
shows that I do not have the funds to pay this void order. It was signed by Stasia Warren under the table. It violated my due process. It violated my 14th Amendment. All of it is illegal. All of it is void. Absolutely none of this is legal, sir. None of it. I also am in the middle of onboarding for the federal government for a FEMA reservist position. I have passed the security background check, and here is an email proving that I'm now onboarding with HR as a part-time FEMA reservist. That requires me to have my driver's license to travel to sites that have been deemed a disaster. So if you take my driver's license, you are taking away my federal job.
If you let the hearing officer talk for a moment. Okay, first of all, I am a hearing officer. I am not a circuit judge. I am, as you are, bound by the rulings of the circuit court. Okay? The rulings are in the court file. I can see them and they do exist. And I took judicial notice of those rulings as I said, at the beginning of the hearing, along with the payment history. Okay? So I can't ignore the rulings of the circuit judge. Now, the appeals court, if they disagree with the rulings of the circuit judge, could certainly overturn them. Okay? But I don't have that authority.
You can't take away my driver's license with an inability
I'm
to
not
pay.
here to take away your
I'm
driver's
not
license.
willfully in contempt of anything. I can't be in
Department of
willful
Revenue-
contempt of a void ab initio order that should
The
not even
Department of Revenue,
exist.
for the record, has, I believe, sent you a notice of intent to suspend your driver's license. Is that correct, Mr. Holt?
Yes, Judge.
Okay. And consistent with that notice of intent, you have filed a motion to contest
Correct.
the suspension of your driver's license, which is your right, and that's why we're here. So, I have determined that based upon the orders that have entered, which I understand you don't agree with, and that you believe should be voided, and that matter is currently on appeal in a court that may have the jurisdiction to overturn that, but I certainly don't. There is a delinquency on the case as we all sit here right now.
Void ab initio.
So, Mr. Holt, it sounds like Ms. Bindle's driver's license could be saved. She's testified under oath that she has a job opportunity that she could avail herself of if she had a driver's license. What is the state, if anything, requesting in order to not suspend her driver's license based on the current notice?
I guess, just for the record, Judge, I've reviewed the documents provided by the respondent. I don't see any evidence of payments made that weren't given credit
Because I don't
to.
have income at this time, sir.
She
I'm not
testified
in
that
willful
she does not have any
contempt.
evidence to present of payments that she's made
So,
for which she's not received credit.
based on the current orders and the clerk's payment affidavit, there is a delinquency.
I'm not in willful contempt.
I didn't say that you were. This is not.
But they are.
And as the court knows, Judge, whether there's a penny delinquency or a significant delinquency, which is the case here, the department's well within its right to take the action that's taken.
So you're going to violate my constitutional rights. On the record.
Ma'am, this is your hearing. You're getting your due
Yeah,
process.
this is
You're
my
getting
hearing. I'm
your
informing
rights.
everyone that you are violating my constitutional
I'm
rights
not
as a U.S.
violating your
citizen.
rights. You're not following a court order is why we're here.
Sir, I've never been in willful contempt.
Judge, we're not here for
If you paid
contempt.
attention to my motion to vacate, you would notice that none of this should even exist.
Okay.
Understand, ma'am, that my
And
main-
you are part of
Okay.
this illegal activity
Ms. Bindle?
if you are continuing to violate
Ms.
my
Bindle?
rights.
Ms.
If you'd like the
Bindle?
hearing to proceed, you would have to have the hearing officer speak.
My function
Please.
here was to determine whether a child support delinquency did or did not exist based upon the current orders, which do exist, and I understand. you
I'm not
disagree
in
with
willful
them,
contempt.
And I understand that they're on appeal.
And my
Okay?
financial affidavit proves
having
I'm not in
been
willful
said-
contempt. This has been filed with the Department of Revenue.
I
I
filed-
have filed a change of
All
circumstance,
right,
and
guys. Just when the courtroom seems to have reached its peak, Heather Bindle introduces another argument that could dramatically change her future. She explains that she is in the final stages of onboarding for a federal emergency response position with FEMA after successfully passing a background investigation. According to her testimony, the job requires a valid driver's license because she would be expected to travel to disaster sites across the country. Losing that license, she argues, would not simply limit her transportation. It could eliminate a valuable career opportunity before it even begins. The hearing officer patiently responds, attempting to separate sympathy from legal authority. He explains that he is not a circuit judge and therefore cannot disregard existing court orders simply because one party believes they were entered incorrectly. While acknowledging that the appeal could eventually overturn those rulings, he stresses that every active order remains legally enforceable until a higher court says otherwise. His responsibility is not to revisit earlier decisions, but to apply the law exactly as it exists today, regardless of how strongly either side disagrees with the outcome. The discussion then shifts back to the Department of Revenue, where the hearing officer asks whether any option exists that could prevent the immediate suspension of Bindle's driver's license. After reviewing her submitted materials, the department explains that none of the documents demonstrate uncredited child support payments or eliminate the existing delinquency. Bindle repeatedly insists she is not willfully refusing to pay and argues that her financial hardship has already been documented. However, The department emphasizes that today's proceeding is based solely on the outstanding balance reflected in the current court orders. As emotions continue rising, Bindle accuses the court of violating her constitutional rights, while the hearing officer repeatedly asks her to allow the proceedings to continue without interruption. He clarifies once again that this hearing is not deciding contempt, guilt, or innocence. Instead, it is limited to determining whether a legally recognized child support delinquency presently exists under the orders that remain in effect. Despite Bindle's ongoing objections and references to pending legal challenges, the hearing officer concludes that the official records still establish an enforceable delinquency, moving the case toward its final resolution.
Change of circumstance, and it is currently in the process.
Let him finish.
A
He
child
might be able
support
to answer some of
delinquency
your
does
questions.
exist, and
And just for the record, Judge, as the court knows, and for the record, under the Florida Rules of Appellate Procedure 9.600, as the court's well aware, child support is one of the exceptions when issues are on appeal. Enforcement continues. Until
Except
that
Justin
issue-
Sterling is hiding my children from me,
Until
and
that
you're
issue
forcing me to
is
pay my
resolved.
rapist when I'm not in
So-
willful contempt.
Judge, the department, as I was stating previously, is well within its right. If she wants the driver's license, $1,000 within 45 days.
I don't have $1,000, and I'm
Otherwise-
not in willful contempt.
Otherwise, it'll suspend.
I'm not in willful contempt. All of this is void. All of this is void ab initio. You cannot force me to pay anything on a void ab initio order. That is law. Illinois had no jurisdiction to sign that April 27, 2022 order, and all of you know it. UCCJEA.
Judge, just for the record, we're not here as to those other issues.
No,
We're
you're
only
here to
for
take
the
away my driver's license on a void ab initio order.
We're here because you filed a motion, man. You
You're
can withdraw
here
your-
to
you can
violate
withdraw
my
your motion if you
constitutional
want.
rights is what you're here for. And I would like you to take all of these exhibits proving that you're violating my constitutional rights right now. I will be filing a 42 U.S.C. 1983 civil action of deprivation of rights, 42 U.S.C. 1985 conspiracy to interfere with civil rights, 42 U.S.C. 1985 action for neglect to prevent, and Alan Holt will be part of that suit in federal court that I will be filing.
one moment, please.
Thank you.
The hearing officer determined that based upon the orders, which the hearing officer understands the respondent disagrees with and has on appeal, and may or may not be overturned, that a child support delinquency does exist. Therefore, I am going to recommend an order to Judge Upchurch, who is the circuit judge in this case.
Please hand all of these to him.
Respondent's driver's license shall not be suspended as to this child support case based upon any notice to date if the responding party pays at least $1,000 on the case within 30 days. This is not a purge. I am also going to direct the department to keep the license valid for that 30-day period as to this case in order to provide her with an opportunity to either pay the $1,000, use the driver's license to earn the money to pay the $1,000, or she also has 15 days to file a motion to vacate the order, which may result from this recommendation if she chooses to do that. Now, that's up to the judge. That's not up to the hearing officer, what happens with that, okay? So, the hearing is concluded. I thank all the parties. You all
Thank
have
you,
a
sir.
nice rest of your day. And please understand, Ms. Bendel, while I am not on your side, I am also not on the department's side.
I'm on the side of the constitutional
okay?
laws.
And, I don't work for the Department of Revenue. I work for the Circuit Court, okay? So
I
thank
am on
all
the side of being a U.S. citizen that has equal rights and protection as a constitutional citizen.
the hearing
And I
is over.
expect that to be treated that way.
Thank you, ma'am.
Thank you.
Have a good rest of your day.
I'm a civil rights advocate, and I will see you in federal court, Alan Holt.
All right, guys, after nearly 17 minutes of relentless arguments, the hearing finally approaches its decisive moment. The Department of Revenue reminds the court that Under Florida law, child support enforcement continues even while an appeal is pending. Based on the existing orders, the department argues that the delinquency remains legally enforceable and recommends a practical solution rather than an immediate suspension. To keep her driver's license active, Heather Bindle would need to pay $1,000 within a specified period. Bindle immediately rejects the proposal, insisting she cannot pay an obligation she believes never legally existed. Despite Bindle's continued objections and repeated claims that her constitutional rights are being violated, the hearing officer remains focused on the limited legal question before him. He explains that his role is not to determine whether previous judges made the correct decision or whether the Illinois order should ultimately be overturned. Those questions belong to the appellate courts. Based solely on the active court orders and payment records currently in force, he concludes that a legally recognized child support delinquency still exists and prepares his formal recommendation to the circuit judge. The hearing officer then delivers a decision that offers Heather Bindle one final opportunity to avoid losing her driving privileges. Rather than recommending an immediate suspension, he proposes keeping the license valid for 30 additional days, giving her time to either pay the required $1,000, earn the money using her current driving privileges, or file a legal motion challenging the recommendation. He carefully explains that the final authority rests with the circuit judge, not with him, making it clear that today's recommendation is only one step in the legal process. As the hearing comes to a close, the hearing officer leaves Heather Bindle with one final message. He emphasizes that he does not work for the Department of Revenue and is not taking sides in the dispute. Instead, he says his responsibility is to follow the law and protect the constitutional process within the limits of his authority. Bindle remains unconvinced, ending the hearing by promising to pursue federal civil rights litigation. What began as a driver's license hearing ultimately transformed into a heated clash between procedural law, constitutional arguments, and a determined litigant refusing to back down.